All right, so we've talked a lot about COVID from a variety of perspectives, but as I was saying earlier, those who seek to use it to get their own agendas through, which might have absolutely no relationship to the virus itself, are seemingly limitless. And when you start to look at the law, oh man, does it open some questions. And so we have somebody who knows all about this and more, who has written a number of articles on the subject and been in court a number of times, probably on this subject as well as many, many others. Quentin Brogdon, he's a Dallas-based attorney who has a lot of insight into this, and he is with Crain Brogdon Rogers.com. And I've got a link on Raleigh.net if you are spelling challenged. So welcome to WGN Radio, Quentin.
Good evening, Raleigh. How are you tonight?
Well, all right. I just saw an article in the New American that the governor of Pennsylvania has vetoed a bill offering protections, and I love the way some of the individuals who had another viewpoint of this typified him, saying he had minimal concern for businesses and so forth. It seems to me that when we start to second-guess the concept of the jury trial, we have minimal concern for the right of people who have potentially been wronged. What do you think?
Well, we have a number of immunity bills floating around. At least 25 states, either through executive orders and state laws, have now granted COVID-19 liability protections. There was a bill introduced in the United States Senate that was, favored. It has not been passed, and it doesn't look like it's going to be passed, particularly in light of who our president appears will be our president come January 20th. But there are some hues and cries to make there be COVID-19 immunity, and the question is whether that's something we should do, and I, for one, think it's not something we should do. I think our system can adapt to this crisis as it has adapted to other crises, and this pandemic is being used in some quarters, many would argue, as an excuse to pursue an agenda, a longstanding agenda that predated COVID.
Yeah, that's my point on this, that seems to be... I used to say that the fastest measurement of speed was the time between a shooting and call for gun control, but that's not it, actually. COVID surpasses that. Every politician of every stripe has jumped on this almost instantaneously for their own agendas, and we're seeing it here. But in trying to deconstruct this from all sides, my first question, and I know you've researched this, is this actually a problem? How many suits that we would normally consider to be misusing the system have been filed?
Well, one of the straw men is that, there will be just this flood of lawsuits related to COVID, and the studies have not shown that at all. Primarily the suits have arisen out of cruise ship exposures, and as you can imagine, there have been some articles in Business Week and elsewhere about Carnival, and it's been really a documented travesty how many people were exposed knowingly to COVID, and so there have been suits filed, but jurors are not stupid. We've trusted jurors before, COVID came along to decide whether corporations owed each other billions of dollars, to decide whether a criminal defendant should face the death penalty. And yet now are some arguing that we can't trust jurors to decide whether healthcare providers, nursing homes, and businesses are taking reasonable steps to protect against COVID. And I think, that's just, if you look at that under any microscope at all, you start to see little brown, dirty things swimming around. It's not at all what it is supposed to and purported to be.
We like to think that the jury will get it right, but of course the old joke, a jury is 12 people too dumb to get out of jury duty, still persists. We also, in the federal system, have, I consider to be a real travesty because of all the people who wind up settling. I think they only bring 2% of their cases now in front of a jury, which is a very frightening statistic that I've read. But apart from the jury, one of the crapshoots, and you're in court probably all the time, is rules of evidence. What can be heard, what cannot be heard. It's almost like it's a Milton Bradley game. And some people are feeling that maybe they're not getting a fair shake at presenting their side of the issue. With regard to this type of a suit, how realistic is that concern?
Well, particularly when you're talking about federal courts, causation, and the role of judges, particularly in federal court, but also in most state courts, they serve a real gatekeeper role. They have the ability to dismiss lawsuits and prevent jurors from ever hearing them at all. Motions for summary judgment, motions to dismiss, motions for failure to state a claim. There are lots of different motions that can be filed. And then you get to the causation element to prove, we're talking about COVID cases, to prove that a particular exposure at work or when you went into a restaurant or when you were in a nursing home actually caused you to contract the virus is easier said than done. It's not a foregone conclusion. And if the jurors don't halt you, it's a fair bet the judge may. And the judge may say, as a matter of law, I'm not letting this case even get in front of the jurors. And judges have incredible power to dismiss cases and to prevent them from ever being heard by jurors.
And that should be heartening to anybody who is using the argument that these cases are going to be a disaster to otherwise innocent players. Clearly, I think what you're saying is that the preponderance of evidence has to be that somebody willfully and wantonly ignored basic safety protocol. But now let's talk about the guy who has been filed against, maybe the small business that people are concerned about who are bringing these bills. And this guy, he's victorious, but now his legal fees have just put him out of business. It becomes a very hollow victory. What is the chance that he can go back and claim his legal from those who are filing the suit against him?
Well, our system generally does not allow the winner, whether it's the person who filed the lawsuit or the defendant who's defending against the lawsuit, to recover their attorney's fees, with some limited exceptions. But you do get court costs. So you can require the person who you prevailed against to pay your taxable court costs in both federal court and in state court. And then there are some other provisions in certain states and also in federal court where you can make offers to settle, and there are certain provisions you can invoke under certain circumstances where you've made a reasonable offer to settle. It's not accepted on the other side, and you end up prevailing. At least in my home state of Texas, for instance, we have an offer to settle statute, a law that's been passed by our legislature. So there are, in many states, statutes, laws passed by the legislatures that at least provide some protection against so-called frivolous lawsuits.
We are talking with Quentin Brogdon, Dallas-based attorney who has a lot of insight into all of the various legal aspects surrounding COVID-19. And there is a dangerous precedent perhaps being sought by all the states, and there was a federal bill as well. I don't know if that was 4317 working its way through the Senate. But I had a question regarding this because there's a certain amount of truth in our legal system, that you can have a hollow victory. You lose everything because your legal expenses were so high in defending yourself from a suit. So my question now is, Quentin, assuming that this was a problem in number of suits, and as you point out, it hasn't yet been, but maybe one suit is too many. Most of us have insurance, and various different professions or entities have various forms of insurance. For broadcasters, we have libel insurance, and there's errors in omission for other companies. Is there an insurance that would cover these small business people, assuming that their practices weren't completely out of hand?
Well, Raleigh, you asked the question of the day, and there's been a lot of litigation, lawsuit activity about that very issue. You've had two types of insurance claims: first-party coverage claims, again, for business interruptions, where the party that has the insurance is suing their own insurer, and then third-party coverage, where somebody who, for instance, comes into a restaurant is suing the restaurant, so they didn't buy the insurance, but they're trying to claim, for instance, under the restaurant's insurance. Mm-hmm. Most general liability policies cover for, quote, physical loss or damage. So insurers are now arguing that for COVID-19 claims, there's been no physical loss or damage. Where was the physical loss or damage? This is a virus. The insureds, the people trying to get the coverage, are saying, well, a, quote, physical loss necessarily includes loss of use. So if I've lost the use of my restaurant or my business because COVID-19 has shut it down, then I have sustained a physical loss under my policy, and I should get coverage. And so then you go to the exclusions under the policy. Some have virus exclusions. If they say we're excluding coverage for viruses, that may well be the end of the fight.
Right.
But if there's a, quote, microorganism exclusion, viruses, some cases have said, are not microorganisms because they cannot replicate outside their host. To be a microorganism, and who knew this, you have to be able to replicate outside your host, and viruses can't. And so those are the kinds of esoteric fights that are going on right now, and it depends on the policy and the state and the specific occurrence, whether there will be coverage. There's no answer. There's no one-size-fits-all answer.
That's interesting. Assuming that there are no exclusions, specific exclusions, because like you say, if it's a viral exclusion, well, you're out of luck. Assuming it's not that, wouldn't this be similar to a slip and fall in terms of someone comes into your restaurant, falls, and they say you're at fault? Wouldn't this be the same category?
That would be the argument if you're trying to get coverage, and then you get into, you say, assuming there's no exclusions, but every policy has some exclusions. So you really just have to read through the policy and see, the policy is essentially just a contract between the insurance company and the party that buys the policy. It says, we will pay money under these circumstances. Some agents are telling insureds not to file because there's no coverage, but I think and others think that's a mistake.
Oh, yeah.
Because if you don't file, that could be waiver of the coverage. So you should go ahead and file, even if your agent or an insurance company is saying, well, there's no coverage. Because if you don't make a claim, you may be giving up the opportunity to pursue it if it's later determined that, you've got coverage or there is coverage.
Oh, absolutely. If you don't make a timely claim, and nothing can hurt you by doing that, I wouldn't expect. To your knowledge, is there any company that is offering policies at this point that would cover COVID claims?
I don't know the answer offhand. Most of these claims, in fact, all the ones that I'm hearing about and looking at, they all relate to insurance coverage that was bought before the virus showed up on this planet, and or shortly thereafter, before it was a real issue in the legal world. So we're looking at policies that were drafted, and the language is just more general. It may reference virus exclusions or microorganism exclusions. It may even have a pandemic exclusion.
Yes.
Some policies have that. But it's not saying COVID-19. Going forward, I predict we will see more specific references to COVID-19. And if you want to buy that coverage, I'm sure they'll sell it to you. You can buy anything for a price.
Well, at a price, yeah, you betcha. And that's similar to the mold exclusions that a few decades ago were unknown and now are pretty much part and parcel of homeowners insurance. So there is precedent for that. All right, we're talking with Quentin Brogdon, Crain Brogdon, Rogers.com. I've got a link at Raleigh.net. And now we'll get into, they're going to push a vaccine on you. And what kind of coverage do you have there? Slim, fat, and none comes to mind. I'm Raleigh James. It's WGN Radio.